Good afternoon, everyone. My name is John Wessey, and I have the pleasure of hosting today's exciting webinar, where we will discuss recent developments in migration law and its subsequent ethical and practical considerations. The opening address will be given by Michael Tidwell, the Chief Executive Officer of the Law Council of Australia, followed by presentations from Anne O'Donoghue, Managing Director at Immigration Solutions Lawyers, Maria Jockel, the Legal Principal and National Leader at BDO Migration Services, and finally, Neil Fergus, the Chief Executive Officer at Intelligent Risks. After our panel has presented, we will have a Q&A around 4 p.m, so do stick around. As I said, our opening address is from Michael Tidwell, and Michael Tidwell has been the Chief Executive Officer of the Law Council of Australia since August 2020, and was previously the Chief Executive Officer of the Law Council of New South Wales. Mr. Tidwell has extensive history in both government and business, specifically in the arena of strategic management and policy advice. He has worked as a senior ministerial advisor and general manager of the ACT Chief Minister's Department. And Mr. Tidwell is a member of the Council for the Francis Forbes Society for Australian Legal History and has recently completed his postgraduate studies at the Said Business School, University of Oxford.
Good afternoon. It is great to be here. If I can thank Anne O'Donoghue, if I can thank Immigration Solution Lawyers, the change that has been before us as we enter this world of post-deregulation is in fact a significant one. I've been very pleased to engage with Anne and with the Migration Law Committee of the Law Council, as I have learned so much about this area of practice. I have realised very quickly that it's indeed a sophisticated area of practice that you undertake, with which you're charged, and the responsibility you have is very significant. The Law Council from which I speak this afternoon is 87 years old, and it has a proud history of serving as the peak legal body of the Australian legal profession. And clearly it takes a close interest in the evolution of the law and the administration of justice. But of course, what the law does and the law informs sits alongside the great social trends and the economic movements in a nation. And immigration in Australia is a challenging issue, but a critically important one. Our country was built on migration and has a rich migrant history. Data suggests that Australia's population of 24 million people originated from almost 200 countries. And we've been enriched by migration. It's been essential to economic growth as well as building regional communities. It is intimately and intricately connected with family law, providing for family unity and recognising the diverse and changing patterns of modern Australian families and global migration patterns. It connects with the criminal law in responding to terrible abuses such as the trafficking of vulnerable people and, of course, modern slavery. It should provide the essential toolkit allowing Australia to realise its international obligations, including those owed to refugees, stateless people and forced migrants. And what a vital role the profession and those committed to this vital area of practice have to play. It was 10 years ago since the directors of the Law Council called for the end of dual regulation. I remember that period very well. I remember being in the room as the Chief Executive of the Law Society of New South Wales when the directors so resolved and the process started with now Judge Chris Kendall, Dr. Chris Kendall, undertaking his review of the Office of Migration Agents Registration Authority, and of course the change that has led to that, which has taken effect as of the 22nd of March, and a significant change it is. So finally, on the 15th of March last year, the Migration Amendment Regulation and Migration Agents Bill 2019 and the Migration Agents Regulation Change Amendment Rates of Change Bill passed through Parliament, ending the need for dual regulation. And the reform is, of course, consistent with the Law Council's long-held objective of a simple, comprehensive and uniform regulatory framework for the legal profession throughout Australia to the benefit of consumers, regulations, and the professional alike. Can I say that when we go through changes such as the end of dual regulation, There are moments which inevitably are clunky and difficult, and that is when we benefit from a webinar such as that this afternoon. And I do thank Anne and her firm for bringing this together, because really the profession, as the community which it does, it always has helped each other, and we'll work through the challenges that we face with the end of dual regulation as a legal community supporting each other. And the Australian community deserves no less as it prepares for this change. Of course, the remit with which I'm associated is broader, and we work closely with our much valued Migration Law Committee, but there is other work ongoing. And if I can just briefly mention two things. One is the work we continue to do in respect to the Migration and Citizenship Legislation Amendment Strengthening Information Provisions Bill of 2020. And of course, the final report of which the Senate Legal and Constitutional Affairs Legislation Committee released it on the 10th of March 21, and which saw the majority report of the committee recommending that the Senate pass the bill slated to be heard, which was slated to be heard, but is still, as I understand it, before the Parliament. And there is ongoing work to do with it, which I would love to address, but I simply, in the 10 minutes I have this afternoon, cannot do so. But the Migration Law Committee continues to do active work in that space. And the second of that is, of course, the active advocacy against the migration amendment, strengthening the character test bill of 2019, which aims to amend the character test in section 501 of the Migration Act of 1959 by inserting additional grounds for when a person will be deemed to fail a character test, and which could potentially be exposed to visa cancellation or refusal where the non-citizen has been convicted of certain crimes. These are complex areas of advocacy. The work in respect of them will be ongoing, but we are concerned particularly in respect of the second piece of legislation to which I referred, that it's likely to increase Australian taxpayers' outlay on immigration detention, to exacerbate critical pressures on legal aid, tribunals and courts, and it may result in fewer guilty pleas before criminal courts and more protracted criminal court proceedings and additional burdens on participants, and may also mean that fewer migrants are willing to seek the protection of the law through things such as those who are family violence victims. So that is all very important work, and it does need, if I may, to be acknowledged that you as a part of the profession and those who work with the profession work in a very contentious area, a stressful area that profoundly impacts on people's lives. And of course, when it comes to migration policy, courts have played an important role in the development of this area of law, and the courts have been central to the development of constitutional and administrative law and principles of judicial review. And of course, you have been a part of that dynamic. And without wishing to focus on the differences between migration agents and lawyers, what I know, because I've been close to it over the years, is that the intellectual skill and the professional ethics and discipline of the lawyer in terms of understanding, interpreting the law and contributing to the law is an incredibly powerful thing, and I implore you to continue that vital work. If I can, in conclusion, as this is a very high level and somewhat racy open to your conference, for which I apologise, it's impossible to drill into the detail of so many things that I'd like to touch on, but if I can just pay tribute to the role that migration law and migration lawyers have played in terms of their practice, because it actually does go to the very heart of nation building. It has been, migration has been a critical pillar in defining the success of this nation. It is an unusual area of practice in that it embraces policy settings which are incredibly complex. And in recent days, as I've been working with the Migration Law Committee and others, and talking with practitioners, and some of them are on the screen in front of me now, that you realise that this is a very complex area of practice. It's influenced by geopolitics, and it's a foundation driver to economic growth, and it speaks much about migration law, and migration practice and policy speaks much about a nation's commitment to social justice. So can I say again, I for my part have been incredibly impressed by the sophistication of the work that you do. Your work is vital for the Australian community and the place that Australia plays within the broader international dynamic. I therefore conclude by wishing you well. There are challenges that arise with deregulation, but there will be opportunities here as well. Opportunities for the profession, opportunities for consumers of legal services, and I hope the opportunity for us to help people who have rights and an entitlement to navigate migration law and the migration system in this country, to navigate it, guided by the expertise, the humanity, and the skill which you appropriate in your practice. I wish you well for the afternoon. I wish all the key stakeholders well as we embrace the change, as we enter this new period. Knowing the skill that you have, I'm confident we will do that, and I wish you well. Thank you very much.
Thank you very much, Mr. Tidball. Our first presenter this evening is going to be Anne O'Donoghue. Anne O'Donoghue is the Managing Director and Principal Lawyer at Immigration Solutions Lawyers, and is one of the top 5 immigration lawyers in Australia. She has specialised in immigration law for over 27 years, but her legal career spans more than 40 years of experience. Anne is an accredited specialist in immigration law since 1998, and finally, she is an internationally renowned lawyer and an active member of both local and global associations of law.
Well, good afternoon. It's wonderful to be here, and such an exciting topic. To all the immigration lawyers that are out there today, I hope you've survived the first days of the post-transition, and we have challenging and interesting days ahead of us. Now, the first slide that I want to start with is just looking at the pre-March 2021 situation, where we had registered migration agents. We have the overlap of the OMARA Code of Conduct, which with the legal profession uniform law, where we were duly regulated. Next slide, please. The new arrangements for the Australian legal practitioner and the end of dual regulation. Michael touched on the migration amendment regulation earlier, which came into effect on the 22nd of March 2021. The legislation removed a registered migration agent who holds an unrestricted legal practicing certificate from the statutory scheme governing RMAs. This means that unrestricted legal practicing holders may provide immigration assistance without being registered as an RMA. The Home Affairs website page has been updated with new tabs to support clients, understanding of who can provide immigration assistance, and includes a new tab for legal practitioners titled Using a Legal Practitioner. Next slide, please. Now, practical steps that lawyers can take to prepare their practice and ensure consumers understand the changes. The removal of the MARA licence from all business cards, letterheads, digital media, social media, and etc., which I'm sure they've been doing. If the process is not complete, it's certainly in the works. You replace your MARA with the Law Society registration number and provide a link to the relevant Law Society to clearly show that the Australian legal practicing certificate who is registered is equally able to give immigration advice. With the dual regulation aspect, we are trying to now show that lawyers are equally able to give migration advice which seems a little bit of a contradiction in terms, but this is the situation that we're facing at the moment. We now are stating that we are equally able to provide this advice. The third step that we suggest is provide links to the Law Council branded pages with links to immigration lawyers and law societies. Clients can deal with legal practitioners with their immigration needs. A temporary website with information for potential clients together with the information from Omara is available at the link that we have on the screen, which is LCA Immigration Lawyers at asn.au. And prepare a narrative, a Q&A or fact sheet that is consumer friendly to explain the benefits of using an immigration lawyer and the need that you don't necessarily have to have a migration agent's license. Consumers now have choice, and how we assist them in making their choice, I think, is very important. Now, there is an Omara update for deregulation, and that notice, there was an MIA notice on the 22nd of March, which said until November the 21st, the Form 1548 will ask for migration agents' registration numbers. Lawyers who previously registered as migration agents who let it lapse should provide their former MANs. They'll need to email the completed form with a copy of their practicing certificates. Now, lawyers who intend to commence providing immigration assistance and who have never been registered with Omara will also need to complete the Form 1548, but leave the question asking for the MAN blank. These lawyers will then email the completed form with a copy of their practicing certificates to legal practitioner at homeaffairs.gov.au. They will receive a 7-digit unique identifier number starting with the digits 55. This identifier number will be used for further IMI account and lodging visa applications until November 2021. So it's going to take the department until November 2021 to get their whole systems fully updated to this. Now, lawyers who were also a registered migration agent, if you retained your MAN number until the 22nd of March, you will automatically be transferred to the Omara lawyer database. Your old MAN will be able to access your IMI account until November 2021. And then the new legal LNP will be rolled out by Omara. You do not need to fill out a Form 1548. Lawyers who did not maintain the MAN registration until the 22nd of March, plus lawyers who'd never been registered with Omara, if you'd like to begin giving immigration assistance, you'll need to complete the Form 1548. And then if you'll need to register that with the IMI account, you'll receive the 7 digits code, and you please follow the link in the sheet to the IMI homeaffairs.gov.au/forms listing forms 1548 PDF. All lawyers after November 2021 will receive their own unique identifier number for the Australian legal practitioner. So there's a little bit of time to go, if we can have the next slide, please, before we get to that. So this will be an interesting transition. I'm sure there'll be some practical issues that are going to come up in legal practices as we speak. Now, information for legal practitioners who relinquish their MAN before the 22nd of March or have never been registered with Omara. You need to go to the Home Affairs website, click on Who Can Help You with Your Application and select the new tab for Australian legal practitioners. Download and complete the new Form 1548 and email the completed form with a copy of the ALPC Holders Practicing Certificate to the legal practitioner at homeaffairs.gov.au. The mailbox will respond with a 7-digit identification number starting with the prefix 55. This number will allow the ALPC holder who has not previously been issued with a MAN to open an IMI account, and the 7-digit number will also be used as a temporary lawyer ID number until such time as the new unique identifier number is provided by the Department of Home Affairs which again is expected in the latter half of 2021. I've also put a link of where this form can be found. If we can have the next slide, please. There is the form on screen now, what Form 1548 looks like. I'm sure a lot of practitioners would be aware of that in any case. Next slide, please. Restricted ALPC holders who are also RMAs who want to give immigration assistance, a practicing solicitor who holds a restricted Australian legal practicing certificate who is also registered as an RMA. This means that they have not completed a period of supervised legal training of 24 months full-time practice or the equivalent part-time, but are eligible to give immigration assistance as an RMA. A lawyer with a restricted practicing certificate who gives immigration assistance in his or her capacity as an RMA must be registered with the OMARA and will be governed by the codes of conduct. However, please note that once you become an unrestricted Australian legal practicing certificate holder, which happens when you've been supervised for 2 years, you will no longer be eligible to act as an RMA. Please also note that registering as a migration agent, if you are a graduate lawyer who wants to give immigration assistance, will no longer be necessary, as the deregulation enables you to give immigration assistance and immigration legal assistance under the supervision of an unrestricted Australian legal practice holder. Next slide, please. Now, if you're unrestricted legal lawyer who wants to remain as an RMA, if you surrender your practicing certificate and you can, and I think this is the question, if you surrender your practicing certificate so I can remain as an RMA with OMARA, are there any considerations I need to take into account which will affect my entitlement to hold an unsupervised PC in the future? Well, yes. The answer to that is yes. You will not be able to maintain your registration as a migration agent with OMARA holding an unrestricted Australian legal practicing certificate. You have to choose between being an RMA or being a lawyer. If you wish to remain an RMA, you will have to surrender your ALPC by emailing the Law Society at registry@lawsociety.com.au. I think this is for New South Wales Law Society. After surrendering your ALPC, if you do not reapply for your AP Australian Practice Legal Certificate within 5 years, your next application for an ALPC will need to be considered by the Licensing Committee as a non-standard application. Now, the new Form 956, I know the Migration Committee had quite a lot to do with discussions with OMARA in relation to that. There are only certain people privy to those discussions with the committee, but the new Form 956 is the appointment of a registered migration agent, legal practitioner, or exempt person. A simple change is to ensure that there is a reference to legal practitioner as a category representative. Paper form must be lodged until the department systems are upgraded to facilitate identification of legal practitioners lawfully providing immigration assistance. You must lodge their updated Form 956 appointment of a registered migration agent, practitioner or exempt person for any new clients they provide immigration assistance after that relevant date. Client applications already lodged in the IMI account prior to the 22nd of March do not require a new Form 956. So the new Form 956 is also available on the department website at the link provided in the presentation. Next slide, please. If I could have the next slide. Thank you very much. Now, filling out the new 956, you'll see question 8. In what capacity are you providing assistance? Registered migration agent. The next box is legal practitioner, IAAS, or exempt person. Now, the registered migration agent's number is still there. I'm understanding that at the moment you can actually put your full practicing certificate number, but it's not ideal at the moment. There's not a separate box for anything but a migration agent's registration number, and there's quite a lot of forms, I think, that are still being completed with old MAN numbers in relation to loading things with IMI accounts. if I could have the next slide, please. Now, the categories of practicing certificates. This is quite an interesting aspect when I looked into it. Under section 47(1) of the Uniform Law specifies 5 categories of practicing certificates: principal of a law practice with or without trust money authorisation, principal legal practitioner of a community legal service with or without trust money authorisation, employee of a legal practice with or without trust money authorisation, employee legal practice of a community legal service, corporate legal practitioner, government legal practitioner, and volunteer at a community legal service pro bono service. Now, these practicing certificates may be subject to supervised legal practice. So you can see there's a whole lot of different categories of people out there in these circumstances working under supervision. Next slide, please. Now, the standards of conduct, the RMAs and the legal practitioners. Well, obviously the RMAs are still under the OMARA Code of Conduct, which is easily accessible on the OMARA site. Restricted ALP lawyers who are also RMAs, who are not supervised by an unrestricted legal practitioner holder in giving legal immigration assistance, are subject to OMARA, the Legal Profession Act, Legal Professional Conduct Rules, and the Law Society Ethics and Professional Practice Guidelines. Now, I've also got a slide that talks about the unrestricted Australian legal practicing lawyers. They're obviously subject to the Legal Profession Practice Act, the Legal Profession Professional Conduct Rules, and the Law Society Ethical Guidelines. Restricted ALP lawyers under supervision of a ULPC holder are also subject to the different acts that are listed there. Next slide, please. I think I've got about 5 minutes to go, so I'll have to race through these. Information for consumers. The main changes that consumers will see for practices specialising in immigration: a simple replacement of the legal practitioner's migration agent's registration number to the Australian practicing certificate. Number will be used in the interim for correspondence. All lawyers after November 2021 will receive their own unique identifying number, legal practitioner LPN. Lawyers will also need to use the updated form 956. Next slide, please. Who can help with your application? Well, there's many people that can help with your application, but I suppose at the end of the day, you want to target the right person for your particular matter. Now, consumer choice is obviously a very important aspect of this, but the consumer must also be well advised as to what choices there are and what consequences flow with those choices. Post the 22nd of March, consumers will be able to choose between an accredited immigration lawyer who holds an unrestricted Australian practicing certificate, immigration lawyers who hold an unrestricted practicing certificate, a lawyer who holds an unrestricted ALPC, restricted ALPC holders working under the supervision of an unrestricted ALPC holder, and of course, a registered migration agent. Next slide, please. Choosing between an accredited specialist immigration lawyer and an Australian lawyer who holds an unrestricted practicing certificate and an Australian lawyer who holds a restricted practicing certificate. The screen, I think, it all depends on experience. It's the level of experience. I think you need to identify the type of problem you have, your immigration problem, and then if it's a high degree of complexity, obviously consider using an accredited specialist immigration lawyer. There are some matters that do require a high level of complexity, and I think with this post change, there'll be just a lot more of this. Why should I use an accredited specialist immigration lawyer? Well, the law societies, both of New South Wales and the Law Institute of Victoria, have very detailed websites that deal with the issue of using an accredited specialist. They are peer reviewed, and it's quite a rigorous process. I sit on the Accredited Specialisation Board for New South Wales, and I'm told that I've got 2 more minutes, so let's move on. This is finding an accredited specialist in New South Wales. Obviously, with the changes, it's easier if you are an accredited specialist for a member of the public to find you. If you're not, if you're just practicing as an immigration lawyer, it's going to be a little bit more difficult. in these circumstances. And this is something obviously that we'll be working on. The Law Institute of Victoria has a similar page in these circumstances. Next slide, please. What is the main difference between legal practitioners, RMAs? I think qualifications, scope of the client, service provisions, and practical training. Obviously, a lawyer's training is a lot more detailed and skilled. I'm not to say that there are not some very expert registered migrations agents out there. I know of many. They do an excellent job, but it's horses for courses and degree of complexity. So I think two more slides. I think we're almost at the end. What is the main difference between legal practitioners, RMAs? Obviously, legal profession privilege is a major aspect of the confidentiality and being able to go to a lawyer in those circumstances. Next slide, please. Ethical responsibilities. I think the Law Council President summed it up. The legal profession in Australia is well regulated and offers of effective consumer protection mechanisms, including the vulnerable people in need of migration assistance. So I think that is a very important point to leave on. I think I'm almost out of time. The paper will be, or presentation will be available to you. I don't want to cut into other people's times, but I'm very much looking forward to the Q&A session which follows. I will now defer to the host, who will introduce the next speaker. Maria Jockel will be following me.
Hello, yes, as Anne did say, our next speaker is Maria Jockel. Maria Jockel is the legal principal and national leader at BDO Migration Services. Maria is also the global leader of BDO Immigration Services and has experience in immigration, or her experience in immigration law is considerable, covering all aspects from business migration, temporary residence, as well as international education, making her an undisputed leading specialist. She has advised both state and federal levels of government on immigration policy matters and has published several academic texts, most recently the 457 visa law addressing Australia's skilled labour shortage. Thank you, Maria.
Thank you very much. And first and foremost, thank you very much for taking the initiative to have this seminar. And it's also lovely to have Michael Tidball as the CEO of the Law Council of Australia making some comments. The first thing I think we need to consider in the context of the industry that we work in, be we lawyers or non-lawyers, is the complexity of our laws. There are 99 visa categories, over 3,000 pages of legislation, which are underpinned by over 50,000 pages of policy guidelines, which we have access to under license. Since 2015, but particularly since December 2017, with the establishment of the Home Affairs portfolio, Australia continues to undertake very significant reforms to the management of Australia's borders. These are profound, they are ongoing, and they reflect the complexity of both the global and the local environment. At the same time, we continue to have restrictive visa-related reforms with a particular emphasis on compliance and regulation as part of the ongoing changes to Australia's immigration laws, and the regulation is the deregulation of lawyers. In terms of the Home Affairs portfolio, no one could disagree that this is a new era to managing Australia's borders. The Home Affairs portfolio is in fact a national security, intelligence and federal law enforcement agency. The Department of Home Affairs is the lead agency. The Australian Border Force is the independent operational enforcement arm. Their responsibilities are diverse and across all aspects of operations, including compliance, investigations, removals and enforcement. The Department of Immigration, Citizenship, Migration Services and Multicultural Affairs is responsible for visa processing, but they are under or subsumed by the Department of Home Affairs. Next slide, please. The Australian Federal Police are obviously responsible for all aspects of federal police and related matters. The Australian Criminal Intelligence Commission obviously gathers and shares criminal intelligence and participates in investigations and operations, including on joint basis and indeed nationally and internationally with other police and law enforcement agencies. AUSTRAC, which is the Australian Transaction Reports and Analysis Centre, is Australia's anti-money laundering and counter-terrorism financing regulator and specialist financial intelligence unit. And last but not least, the Australian Securities and Intelligence Organisation, namely ASIO, Australia's Intelligence and Counterintelligence and Foreign Interference Agency. We have never, ever, as immigration lawyers in the past, worked in such a mega portfolio, which brings together these significant independent security and law enforcement agencies and are complemented by a whole of government approach, which is both national, international, and of course, international, obviously with prescribed agencies overseas, but also, of course, within Australia. Next slide, please. The Department of Home Affairs is overwhelmed with applications. In November 2017, the then regional commander of the Australian Border Force told me the department was getting over 30,000 applications each day. A couple of years later, the department predicted a 50% increase by 26-27. Last year, the department raised some 3.25 billion or thereabouts in visa fees, fines and levies. In contrast, in 2003, it raised some 320 million in visa fees. This tells you that the Department of Home Affairs, the Home Affairs portfolio, are indeed overwhelmed with the number of people wanting to enter this country, the nature of globalization, the movement of people across borders, and the extraordinary demand for temporary and permanent entry. It also shows this once in a generation change. This is a Department of Home Affairs term, not mine, and it touches on every part of Australian life, including business, trade, and travel. In terms of the role of the Australian Border Force as the frontline operational border control and enforcement entity within the department, the depth and breadth of the Australian Border Force should not be undermined. It delivers on national, international, regional and local border protection, national security priorities. It enforces customs and immigration laws. They are responsible for all sponsor monitoring and enforcement, field compliance, including unlawfuls, character considerations and assessments, identity investigation and case management. Identity fraud and documentation fraud is a perennial challenge and issue and is pervasive across the whole of the regulatory compliance challenges. In addition to that, next slide, please. The Australian Border Force is responsible for compliance and regulation, which includes border protection, as I said, character, compliance, case management, identity, investigation, removals, status resolution, surveillance operations, and targeted enforced operations. I think we could have a half-day seminar just on the role of the Australian Border Force. Next slide, please. We know that the Commissioner of the Australian Border Force is equal in rank with the Chief of the Australian Defence Forces and the Australian Federal Police. His powers are held concurrently with that of the Secretary of the Department of Home Affairs, and he reports directly to Minister Dutton, who, as we know, was previously a police officer in his former life. Next slide, please. In regard to sponsor monitoring and compliance, the non-uniformed sworn officers of the Australian Border Force are responsible for all sponsor monitoring and compliance, and they do that in conjunction with other government agencies as may be necessary. But they also do that for interviews, site visits, unannounced and announced, desk auditing, and then of course working collaboratively across other sections of the Home Affairs portfolio, which I touched upon briefly, and in conjunction with agencies such as the ATO, Fair Work Ombudsman, ASIC and others. Next slide, please. As we may be aware, the Department of Home Affairs has an armoury of powers, and the legislation that we are subject to has very, very significant legislative powers in all aspects of what we do on a day-to-day basis. Most particularly, the Enhanced Integrity Act, which was passed in December 2018, allows the Minister of Home Affairs to in effect name and shame corporations and individuals if they operate as an individual operation, should they fail to meet their sponsor or former sponsor obligations. And that's in particular in regard to whether the person works in a nominated occupation and whether they're paid their correct salary. In this slide, there's an example of a published such publication whereby in fact the details of the entity, their ABN, etc., the nature of the breach, the fine or whatever other action was taken against them is noted. Again, the Enhanced Integrity Act is a complex legislative scheme. It deserves significant consideration. But moving on, please. The Enhanced Integrity Act was passed in conjunction with the data matching protocols, which have been in existence since the 2008 onwards, which the ATO in particular has been undertaking, and is in conjunction with the income tax assessment legislation. It allows the collection of tax file numbers, the sharing of data between the ATO and the Department of Home Affairs to support the integrity of Australia's tax and related systems, maintain the community confidence in those systems, and the data is matched based on about 50 indices, including that of the visa holder and the entire profile, the employer and their profile, and of course the migration agent communities, which of course now legislatively would also include legal practitioners. So the Enhanced Integrity Act and the data matching with the ATO is part of the perennial use of data, in this instance by the ATO to as part of its risk detection models for administrative action, including in relation to tax return integrity, income tax superannuation, other non-compliance, and, for example, fraud. So again, this is an example of how the exchange of data on a periodic basis can enhance the basis upon which various agencies, most particularly the Department of Home Affairs, in conjunction with the Australian Border Force, and when necessary in conjunction with other agencies such as the Fair Work Ombudsman and the Australian Taxation Office, can undertake regulatory compliance. Relevantly, between 2017 to 2020 financial years, the ATO advised that it was going to have data on about 20 million individuals. That is a significant amount of information about a very large number of individuals. In addition to that, single touch payroll allows real-time payroll data analysis. It allows for quick identification and action on any anomalies or non-compliance, including under the data matching protocol. We all know that since 1st July 2020, most businesses must comply with the single touch payroll rules. Next slide, please. So the Enhanced Integrity Act, in conjunction with data matching, basically allows an enormous exchange of data. The data includes income tax returns, payment summaries, employment details, tax file numbers, payment summaries, ABNs for all employers who issued the visa holder payment summary or who the visa holder has declared on their tax file number or income tax return, and any related data from single touch payroll, be it in regard to superannuation tax or otherwise. This is a slide which is not readily available, and I'm very grateful that I came across it. Consolidated view of risk. In this highly complex, dynamic and ever-changing area of law, the Department of Home Affairs has perennial instructions, many of which we cannot get access to because they are subject to security clearances and only available for official use. But it's important to note that our perceptions of risk may not necessarily reflect the perceptions of risk of those decision makers that we work to. And remember now that with an entirely e-lodged system that we never know who the decision maker is. Everything is done digitally. So risk insofar as the department is concerned can include any aspect of anything that is lodged, and it may be perceived that what is lodged is fraudulent or false or misleading information or documentation to support an application, or that the person is not genuinely intending to come to Australia for the purpose of their visa type, or that they don't intend to comply with the conditions of their visa, or that there is criminal bad conduct, or they may pose a security risk or a risk to public safety, or indeed the good order of the Australian community. So you don't need to have criminal convictions to fall within the view of risk. General conduct, as we know, are adequate provisions, particularly under Section 501 of the Migration Act. Next slide, please. We also now have a data processing centre. Now, this was established, as I understand it, in 2015, and this we have a range of risk matrices that the Department of Home Affairs works with, which are very synergistic to that of the ATO and other major agencies, and combined with the online lodgement system. Basically, what this means is that there is an enormous amount of data relating to matters which may be relevant to matters such as threat identity, biometrical capabilities, matters relevant to mitigating risk, applying rigour to visas delivery service, and most importantly, the network of analytics, visualization capability and intelligence, information sharing and risk management capability within the entire visa system, automated analysis of data, including advanced analytics underpinning business and visa processes. Next slide, please. So what does this mean for you and your clients? Well, what does it mean for all of us? Because after all, this particular agency, the Home Affairs portfolio, the ongoing transformation of the management of Australia's borders, in fact, touches upon every aspect of what we do, be it in our personal lives in business or be it in travel. The closure of Australia's borders has shown that Australia is the only nation in the world that could overnight close their borders on the 20th of March 2020, keep them closed, have a COVID-led induced recession, but nonetheless continue to be only focused on the safety and of the Australian community. So we will continue to grapple with the labyrinth of Australia's highly complex, dynamic and codified laws. They're constantly changing, they're highly restrictive. The power and reach of the Home Affairs portfolio, the Department of Home Affairs, the Australian Border Force and the other agencies underpins Australia's national security, intelligence and law enforcement operations. Data collection is really the new oil. Data is the new oil. It provides an enormous amount of information which we may not be privy to when we act for somebody, because we're not necessarily aware of all the other things that they may have made known to other providers, agents or lawyers or other individuals or employers in respect of their circumstances, or if we're acting for the employer, what the employer has otherwise advised government agencies, be it the Department of Immigration / Home Affairs or others. So all of these things expose us to significant risk as advisors, because what we have to understand is that there's an overarching public interest, which is to review visa fraud, to ensure sponsorship monitoring is effective, to address fraudulent Phoenix activity, to address unlawful employer and labour hire practices, to detect, investigate and prosecute cases of breaches of the law. There is so much that we do not know, because we are not national security operatives, nor do we have the requisite security clearances to get access to the vast amount of policy guidelines, which we broadly refer to as Legend Com. So I think that we just have to recognise that data sharing is here to stay. It will grow. It will continue to be exploited and mined in a way which will best serve the interests of the Australian government and the community, because at the end of the day, what the government is making clear is that Australia is a sovereign nation. It relies on the rule of law. There's an overwhelming demand for temporary and permanent entry. Most Australians would say it's entirely unsustainable. There's a focus on protecting Australian jobs and on community safety, hence the health measures that have been undertaken, including by the National Cabinet during the closure of the borders. We also have the end of dual regulation, and this is an opportunity for legal practitioners who specialise in immigration law to best safeguard their clients' interests. This is an extraordinarily complex area of law. Since 1994, and that's not in the slide, over 500,000 pages of information were created, and that was only up to about 2017. The information that continues to pervade this most complex and important jurisdiction is well beyond what any person can say that they are truly expert in. All we can expect is this: there will be more changes ahead as Australia continues to manage its borders in these dynamic, both local and global times. And from my perspective as an accredited immigration law specialist, I'm very choosy as to who I act for, on what basis, and on what basis I decide to put down my practicing certificate so that I can in effect continue to be the best that I can. It is up to each and every one of you to decide what this means for you. I'm not here to preach or to say someone's right or wrong. Having worked in government, I learned one thing, and that is that information is power. This is simply the tip of the iceberg. Thank you very much for listening. I believe that we have another speaker now.
Thank you very much, Maria. Our final presenter for today is Neil Fergus, the Chief Executive Officer at Intelligent Risks. Neil founded Intelligent Risks in 2001. The company has subsequently developed into a leading international provider of crisis management, risk and security services. In the past 2 years, Intelligent Risks has been awarded the OSPA as an outstanding security consultancy in Australia. Neil has enjoyed a highly successful 20-year career in government, most prominently as a senior diplomat for DFAT in Europe and the Middle East, as well as principal operations advisor for the Attorney General's Department. Neil has been engaged as a senior advisor to the Commonwealth Games Federation since 2004 and has participated in planning and delivery for 9 Olympic Games. Thank you, Neil.
Thank you. Great pleasure to be here, ladies and gentlemen. I'm going to provide, I suppose, in a sense, a non-legal perspective on some of the matters that my distinguished colleagues have spoken about so adeptly. As has been clear, and I'm sure as everybody listening is aware, Australia has always been and remains an extraordinarily attractive destination, not just for tourism, but for migration. Inevitably, as Maria has pointed out very acutely, there has always been a small minority in that migrant applicant stream that have either falsified, cloaked, or deceived about their background details to enhance their prospects of being issued a visa. Government analysis informs decision-making for the purposes of trying to reduce visa fraud and, of course, to detect, investigate and prosecute in cases of breaches of law. Perhaps a little context to, and I won't repeat what Maria has said about the generational changes which have occurred in federal government in recent years. But if we go back, it has always been the case, and the first ASIO overseas diplomatic postings weren't in Washington or London. They were in Copenhagen and Vienna in 1949, specifically to assist the Australian government to look at the displaced persons, and there were hundreds of thousands of them, seeking to relocate to various places, including Australia. And the purpose of those postings was to try to identify people who were implicated in Nazi war crimes. And then as the Cold War emerged, there was still a requirement to try to detect those persons hiding their involvement with Nazi and fascist parties and regimes, but it was also to find Bolsheviks in that early Cold War era. And as a consequence, the Australian government developed a very strong cadre of senior immigration officers and principal migration officers, supported by locally engaged staff in diplomatic positions all over the world to manage the migration filtering or assessment programs. And in liaison with national security agencies, they were extremely successful, but it is an imperfect science. And the reality is, and again, Maria has alluded to this, there are still people who somehow manage to thread their way through the system. And we can talk a little bit about that in the time available, but just briefly. More recently, and again, Maria's touched on this, the cadre of specialist SMOs and PMOs has been reduced. as we have got into a more digital analytical program, and the systems which are being used are very sophisticated, which enables the Department of Home Affairs to deal with the huge amount, the huge volume of migrant applications that are coming through more efficiently than was done in a previous non-digital era. But there are pluses, strong pluses, but there are also some other consequences of that. If we can change the slide, please. So there are some performance issues because we don't necessarily have the same degree of subject matter expertise within the department in terms of the countries or the regions, as might have been the case when there was less volume and a more frontline person dealing with the applicants. All of this, of course, means that migration agents and, of course, ULPCs now play a much more important role than was the place in the previous generation. And in that context, the RMA Code of Conduct is very important. It's an important tool in reminding the agents, of course, of their responsibilities in terms of assisting to manage down the extent of dubious or fraudulent applications. And of course, unrestricted Australian LPCs are subject to legal professional codes of conduct. And in fact, the same matters apply in terms of the ethics of the profession. And again, Maria spoke about the fact that she does not accept every client that bangs on the door of her practice. There are some judgments that need to be made, and not to try to replicate the authority, the power, and the statutory authority of the department, but some common sense ethics need to be applied. There are common and continuing challenges, and indeed the Global Talent Visa Scheme is an example of something that has been recognised by the department as enabling, inadvertently, some fraudulent activity to take place. So that scheme is currently being reviewed and tightened. It's a tangible illustration when we've seen instances of, no disrespect to hairdressers and truck drivers, but hairdressers and truck drivers arriving in Australia with duly notarised documentation showing higher education qualifications, and in some cases, illegitimate police background checks. I won't say fraudulent because in some cases they've been forgeries. In some other cases, they are legitimate, but they are not factual. They have been bought. And the challenge that everybody in this sector faces, from government to lawyers to migration agents, is we are dealing in some instances on the geopolitical stage with uncheckable backgrounds. The reality is the Australian government takes a forward-leaning approach in terms of humanitarian circumstances. For example, it's quite conceivable we'll see an influx of Rohingya migrants in the not too distant future, given the events that have just happened in Myanmar and the fact that so many of them were arbitrarily pushed out of Myanmar into Bangladesh. But the point is, we have no capacity to have any fidelity about background checks being done in Myanmar under the military junta. We don't have any fidelity in terms of checks being done in Iran or North Korea. And regrettably, while there was some fidelity in terms of China, that is not necessarily the case anymore. I think it would be fair to say that it is a case-by-case basis. We are still able to get legitimate police checks from China in some circumstances, but not in all. Conversely, with the contraction of country subject geographical matter expertise within the department, we've also seen a few legitimate applications being denied or in fact, visas cancelled. Now, that's not, fortunately, a regular occurrence. And clearly, again, as Maria had pointed out, the risk parameters the department takes to protect Australia and its national security. And unfortunately, that means there are occasionally some judgment calls made for the benefit of Australia's national security, rather than necessarily because of some incorrectly completed form or misunderstanding at interview dealing with an applicant. That is the nature of the beast. But we have seen an instance where an individual with a bridging visa was subject, well, the Migration Review Tribunal was told that the individual was the subject of an outstanding Interpol red warrant. In fact, it was the case that that person was the victim of a case of mistaken identity. There are some very common names in the Anglo world, Smith Jones, but certainly when we look at mainland China, for example, you know, the Wangs and so on, equally a family name which is taken by millions, not tens of thousands, millions of people. So that's one of the issues that needs to be dealt with. And the reality is there is a shared ethical responsibility. Sensible, proportionate risk analyses, and I don't mean a fully documented risk analysis, but risk judgments need to underpin the programs and actions of RMAs, ULPCs, and of course the Department of Immigration, Citizenship, Migration Services and Multicultural Affairs, as it does with our national security agencies. And again, it's stated earlier, the reality is that a number of the adverse findings in relation to some of these applicants come through our intelligence services. And that material will be redacted in terms of the proceedings of the Migration Review Tribunal, quite properly, to protect the sources. And in some cases, because there is an obligation, a ministerial agreement not to reveal that information has been passed to Australia by an organisation or service in another country. So that needs to be honoured as well. So the point is, this is a change. It's a big transition that is occurring in this sector. There are challenges, undoubtedly, but it is moving forward in a way which is designed to give us some better surety as a nation that the migration stream is going to be fair, equitable, but also consistent with what our national security objectives are. And it's clearly in nobody's interest for us to have some sort of setback in terms of increased fraudulent applications, because these are arguably not the people that are going to make a contribution going forward in the way that, thankfully, the vast majority of migrant applications do. I think I've just about exhausted my time, but as with the other speakers, I'm delighted if there's any Q&A that I might be able to assist with. Thank you.
Thank you very much, Neil. I found that most interesting. It looks to me with some clients, I think we probably need to use your services and get a risk assessment done, whether we take someone on or if we have got concerns, because there are quite a few situations where you need an objective assessment. And I know personally in my practice, it's a situation where sometimes people's rights are, they're not given their full rights. And there are examples where information is not correct and it is provided to agencies. And then that can produce an unfair outcome for a particular visa applicant. It can even produce a cancellation of an existing visa. So I do think assessment of risk now is becoming a key criteria and a skill that migration advisors, whether they be lawyers or migration agents, need to take into consideration much more than in the past. One would look at a client, one would do relevant checks, but I think we've got to go a step further. What is your viewpoint on that? Do you think lawyers and migration agents need to go that step further?
Directing your question to me, Anne?
Yes, I am.
Yeah. Look, in a small number of cases, because I think that what we're talking about is experienced persons operating in this space, RMAs or lawyers, obviously have the expertise to make judgments more often than not. But there are complex cases coming from sometimes murky geopolitical circumstances. And if that's the case, then if the person, well, as you and I have discussed in the past, the onus is arguably on the applicant to demonstrate in some of these cases that they do not pose any security risk, that they do not have a criminal record. When you can't get a correct criminal record check, you need to adduce whatever other information is possible that can be corroborated to support their submission. Now, fortunately, that's not a common occurrence, but in some cases, depending on where that person comes from, it's challenging. And you can understand the department saying, well, if you can't provide us with the criminal police check, why would we progress this application? That's where I say the onus of proof goes back to the applicant.
Yes, it is a sort of a challenging area, something that I think we need to keep working on. And adducing evidence, of course, is a major issue and not easy in countries where there's just a blank wall in relation to getting that type of background checking done. So it does.
As I'm sure Maria and you know, in COVID-19 world, trying to get a criminal record check from Mexico recently, they have closed the office. They have no intention of issuing any such checks in the short to medium term.
No, it's a very different world, a global world we're operating in. And I think for those registrants that are listening out there, it's not the same playing field that we've played on before. It's a totally different playing field, which is going to necessitate, I think, many different skill sets. Maria, perhaps you'd like to make a comment on that particular point.
Well, thank you very much for the opportunity to comment. I think the intention of my presentation was to give the viewers some understanding of how fraught this area is with risk, and particularly those of us who are lawyers and have practicing certificates, how important it is, given the nature of the agency that we're working with, to be not only expert in what we do, but to understand that immigration is now really integral to national security, and it is, as we all agree, nation building. In regard to matters relevant to character and identity, of course, that's the requirement of the individual to evidence that. And as we can appreciate, as in the case of post 9/11, where you couldn't get police checks from the USA, currently the world is in a state of uproar, and it's extremely difficult to get police checks from any nation. And of course, we can understand that because national police authorities are focused on matters that are priorities to them, rather than the fact that an individual may want a police check for visa purposes. So I think, again, people have to work out what is it that they want, who are they going to, what are their circumstances, what do they have to evidence in those circumstances, but most of all to ensure that they comply with the law, because it's the only way that anyone's going to be able to have a chance of staying in Australia lawfully. And if there is anything that's untoward, we've got a whole armory of powers and multiple agencies which can ultimately find out information about that individual in such a way that it could unwittingly even embarrass the advisor who took that client on. So it's multidimensional, multifaceted, and an area which is both dynamic and interesting, but also, I think, in my view, requires certain circumspection.
We have one question from a young lawyer who is just moving into the area of immigration and is working in a firm that doesn't specialise in immigration. Is a general practice and working under the supervision of a full practicing certificate holder, and is concerned about direction in relation to, and if she is asked to give advice on an immigration matter. Maria, perhaps you'd like to make a comment on that question first.
I think anyone who works in this jurisdiction, first of all, it's not for the faint-hearted. Secondly, whether you're a junior or senior lawyer, I think you've got a perennial obligation to be a perpetual student and to study this legislation, read the regulations, read the policy guidelines, and become as familiar with the matter as you can. Whilst you may or may not be subject to very informed supervision, at the end of the day, it's your career. And obviously, if you've got a very informed and expert supervisor, that makes your life easier because you've got a nice safety harness and a full back position. But not everybody is working in that environment, in which case, clearly, they're required to be able to do a lot more leg work themselves, more so than perhaps would be otherwise the case. I think each individual has to manage what I call broadly quality assurance and risk as they see fit. But if you're working in a firm where the person who's oversighting you is not an expert in the jurisdiction, it certainly makes your job much more challenging. And I think in those circumstances, you appraise yourself of what you've got to know, but you also let your supervisor know that in your view, you may have some challenges in being able to undertake the task because this is not an area that you're expert in, and you are aware of its complexity, and you're aware of the potential risk, not only to yourself, but the firm broadly, if the matter goes wrong. Now, that may require a bit of courage on the part of a young practitioner, but if you don't speak out, you're not going to be able to safeguard the interests of yourself, your client, and the firm. And remember, whether you've got a restricted or an unrestricted practicing certificate, you're an officer of the court, you've got a responsibility for due care, you've got a care, skill and responsibility obligation, and as an officer of the court. So if you're doing work that you're not equipped to do, then perhaps you may decide it's not prudent to do it.
Yes, I think it is difficult for young lawyers in these circumstances, but I think they should definitely speak up if they feel that they haven't got the supervision that they need, because these young lawyers now, with the deregulation, will be able to give out immigration advice under the supervision of a principal. And I suppose the same applies for a registered migration agent working in a migration agency firm, that if a matter of difficulty does arise, you really do need a mentor or someone in supervision that you can go to get advice and direction. I think younger people, young lawyers, young migration agents are sometimes a little bit hesitant to get advice, but there's many courses, CPD requirements, and I would encourage people out there who are listening today to make the most of the CPD. I think the MIA does a particularly good CPD, which is the Migration Institute of Australia. And I think skill and expertise are going to become very important aspects moving forward. We have a whole host of different questions here that have been coming in. Any advice you can provide on completing a Form 424A by immigration lawyers? Now, that's the Freedom of Information. I believe the changes have been made only to Form 956. Well, that is my understanding too. There is no provision at the moment with the Freedom of Information request to make an allowance for an immigration lawyer to make that request. Now, to our audience out there, of course, a Freedom of Information request can be vital when you're taking over a matter that has either been badly handled or the client has done it themselves. You need to get that background on the client's file. Have you noticed anything in that regard, Maria, since the transition?
Yes, the forms will not be updated, as I understand it, in all until November 2021. So I think it's just going to be incumbent upon us, if we are lawyers, to submit the form, and it will be clear, I think, from the cover correspondence that you'll make clear to the department that you're in fact a legal practitioner with a current practicing certificate. If you've got an unrestricted legal practicing certificate, obviously you won't be listed on the OMARA. If you've got a restricted practicing certificate, it's likely that you'll continue to be listed. And while we've got this transitional arrangement, I think it's just managing as best as we can to communicate with the department who we are and the basis upon which we are acting. The Form 424A is an extremely important form because obviously it's the basis upon which a valid freedom of information request can be made. And we know that if the form's not completed appropriately, you might end up with an invalid request, which can then delay the whole process by many months.
I mean, there is a big problem with the getting these searches within a timely manner, and the last thing you'd want to do in that case is just delay it even further. So I think freedom of information requests are going to be more and more important and relevant. Let's hope that the department may be able to fix this particular form a little bit faster, because this is also, I mean, compared to the 956, which is your authority form, which is vital, which is like a foundation block, the 424 form is the next form, which I think is extremely important. We have another question. We have many questions. I hope we can get through them all. I submitted the completed form 1548 as a restricted ALPC lawyer on the 22nd of March. When can I expect the 7-digit number? I hope the answer is not November 2021.
I don't think any of us are in a position to comment on that.
No.
But it would be interesting to know how long this process does take.
Mm. Yes, well,
it's only once you've got that number that you're going to be able to access the IMI account. And I would imagine that there will be quite a lot of behind the scenes technological IT work that the Department of Home Affairs has to undertake in order to facilitate people being able to be given that 55 prefix number.
Yes, it will be vital to get that number. I suppose it's just a wait and see, but it's a sort of a limbotic state that we're in now. We no migration agent's license, yet we can give advice as immigration lawyers, which is wonderful in the sense that one is no longer duly regulated, but the practical transition, I think, is still going to raise some challenges, and I think I can only advise people to just work through every matter on a case-by-case basis, and certainly reach out to the department at a senior level if you do find a roadblock or you feel that your client is being unfairly disadvantaged through this, which I hope is not the case. I hope people are not in that situation. Let's see. Why should I choose an accredited specialist immigration lawyer over a registered migration agent? I suppose that's a very controversial question, but I suppose it is a question of really consumer choice in these circumstances. As I pointed out before, there are some very experienced registered migration agents. I think it depends on the complexity of the particular case. You can't look at, there are transactional matters, there are litigation matters, there are tribunal matters. I think it's very difficult to draw an answer. You should look at the skill and expertise required, but the consumer has to have a knowledge of that, and we assume that the consumer will have a pre-existing knowledge. In some situations they won't. What is your viewpoint about why you should use an accredited specialist lawyer, Maria?
It's not my job to persuade anybody. People come to me of their own accord. They decide whether I've got the capacity to undertake the job in the very best way. I think that the consumer needs to consider the fact that they have got a choice, as you said earlier, and they've got to look at the nature of their case, how complex it is, how important it is for them to get the visa approved. After all, you can't get half a visa approved. So it's really a personal choice, like in every other aspect of life. Who's best suited to undertake the case, and what are you prepared to pay for the service, and will you get the results that you hope to get if you engage that particular individual as opposed to somebody else. You cannot, there's no one size fits all. Make a choice, and if you're the individual visa applicant, take the consequences, whatever they may be.
Well, we've got 5 minutes left on the Q&A. Yes, I suppose the consequences are, unfortunately, I'm sure there's a lot of experienced lawyers out there listening today that have often seen a case come before them that if they'd seen it earlier, they could have fixed it or could have saved some aspects of it. A lot of this is to do with inexperience, and I think it is important to try and choose someone with experience. It is a matter of consumer choice. We're not saying anyone is better than anyone else. However, consumers now are faced with many different choices since the end of dual regulation. There's various different categories of lawyers in different areas of expertise. There's different categories of migration agents with different levels of expertise. So I think you need to just do your research. Referral is always a good thing. Most law societies also do have a list of accredited specialist immigration lawyers that you could choose from. But again, with using any professional service, choice is very important. Neil, have you got any comments from a security point of view in relation to the consumer choice in this area?
Well, again, I'm not practicing as you people are. I guess my point to anyone who asks me is make sure you go to a firm which has experience in dealing with this, because not everybody who is seeking to assist people into the migrant stream are actually as skilled or experienced as some of the people who were talking here today. And no, it's not a paid advertisement, but the thing is, it's an expensive process for a lot of people, and it's a time-consuming process, and it requires some patience, and you obviously want people to get the best possible representation.
Well, that's right. I mean, whether you use Immigration Solutions, whether you use BDO or whatever, we're saying it's a matter of consumer choice. Do your homework. Yes. There are some very good migration agents out there and very good immigration lawyers out there. The choice is wide open. There'll be a lot more lawyers coming into this field of operation. And I think experience and their record is important. The more complex of issues certainly lead to a conclusion that you need to use someone who is very experienced. Now, Marion Dickey, who is a very good friend of mine from ANU, I don't know whether it's a Dorothy Dix or not, but she said, if you have time, I'll speak to you why I think deregulation would be a good thing. Well, I'd love to speak to Marion about that. Congratulations, I think, on her doctorate or PhD that she just recently achieved. I'm an eternal optimist. I believe that deregulation is a good thing, and I think we can all work with the industry, which is migration agents, lawyers of different descriptions, different levels of expertise. I think we can work all together to get a better client outcome, because that's at the end of the day what we're there to do. So I think I'll just defer to John, who'll be thanking everyone. Marion, you're online. The wonders of technology. How are you?
Good, thank you. I will take 1 minute of your time.
Well, I'll give you two. I'll give you two.
Thank you. Hello, Maria, as well. It's nice to see you. I have finished my doctorate. The doctorate was about migration agents. I believe it's the only one ever done in Australia about migration agents. And one of the key things I found that has held back the migration agent profession is deregulation. So there was 3 things that held us back. One was deregulation. One was the lack of a professional body that was coherent. You know, for a long time, MIA was the MARA, and then we split up into different bodies. And deregulation has always been an issue that has divided the profession. The fact that migration agents haven't got an independent profession, very much like the lawyers have, has held back on their ability to be supervised, have supervised practice, and that has held back on their ability to prepare or develop their ethical and professional practice amongst their peers, because we've had a fractured profession of different peers who all come in with different levels of education, who belong to different societies like the Law Society or the Migration Agent, the MIA or the MA, and it's always fractured the landscape we're practicing in. So for me, I think deregulation is a great thing. It will get the migration profession, which I think is an emerging profession, it will get it up off the ground, independent, and hopefully be able to work collegially, as they have in many instances, with lawyers practicing in this specialist area. And your demonstrations today, Maria and Anne, on how complex it is, have highlighted why lawyers are particularly important in this area of migration law. And also, I really want to thank you for the respectful way you've talked about RMAs today and how they can work together with you. So I hope that's a coherent explanation for you. I went through it quite quickly.
Well, we look forward to the future, and I'm sure we can do a further seminar where it'd be great to have you as a speaker. But I'd just like to thank everyone today. I think the host, John, is going to just say a few words, and my personal thanks to all the speakers, and in particular, Michael Tidball, for the opening address. It was great to have Michael there.